The House Committee on Judiciary will now come to order. Madam Secretary, please call the roll.
Evans.
Here.
Beat. Here. Ellabrock. Here. Anderson. Here. Black.
Here.
Davis. Here. Mackey. Reedy. Riley. Here. Sauls. Schroer.
All right, we do have a quorum. Now move into executive session. I move that House Bill 2614 be voted do pass. Discussion. Representative Black.
Thank you, Mr. Chair. I have an amendment ending in .01H. It has been distributed. I move for its adoption.
Discussion on the amendment. Just a question by the chair. To your knowledge, did the bill sponsor agree to this?
He has, Mr. Chair.
Other discussion by the committee?
Thank you, Mr. Chair. The amendment clears up some lack of specificity in the original bill, in my opinion. I appreciate the bill sponsor working to address those circumstances. It defines the departments in question as opposed to the just generic term department, as those departments authorized to allocate funds for homelessness. It provides specificity with regard to some of the facilities that the homeless population could be authorized to use under this bill. It specifically provides that individuals utilizing such facilities are to be entered into a management information system to be maintained by the Department of Health. It addresses the liability immunity issue raised by a member of the committee by referencing the already existing campground liability provisions we have. It provides specificity with regard to assisting the homeless with the issues that many of those have. It addresses the issue of, in more specificity, trying to keep the homeless off the street and in places where they might be helped. And that's just a brief summary of the amendments, Mr. Chair.
All right, there's several. Any further discussion? Allow questions of the amendment maker. Anything else by the committee? Seeing none, all those in favor of adopting House Committee Amendment 1 signify by saying aye. Aye. Opposed, no. The ayes have it. You've adopted the amendment. I now move to roll House Committee Amendment 1 into new House Committee substitute and adopt the substitute. All those in favor signify by saying aye. Aye. And opposed, no. The ayes have it. You've adopted the substitute. I now move to House Committee substitute for House Bill 2614 be voted do pass. Discussion. Seeing none, Madam Clerk, please call the roll.
Evans.
Aye.
Beat. Aye. Ellabrock. Aye. Anderson. Aye. Black. Aye. Davis. Aye. Mackey. Reedy. Riley. Aye. Sauls. Aye. Schroer.
By your vote of 8 ayes, 0 noes, your vote to House Committee substitute for House Bill 2614 do pass. I now move that House Bill number 2660 be voted do pass. Discussion. Representative Eaton.
Yeah, as the concern of our fellow members here, there was concern about the word arbitration in there, and we understand that when it goes to the floor, there will be some additional discussion on the use of the word arbitration.
All right. Any further discussion? Seeing none, Madam Clerk, please call the roll.
Evans.
Aye.
Beat. Ellabrock. Aye. Anderson. Aye. Black. Aye. Davis. Aye. Mackey. Reedy. Riley. Aye. Sauls. Aye. Schroer.
By your vote of 8 ayes, 0 noes, your vote at House Bill 2660 do pass. Now move that House Bill number 1551 be voted do pass. Any discussion? Seeing none, Madam Clerk, please call the roll.
Evans,
Aye.
Beat. Ellerbrock. Anderson. Black. Davis. Mackey. Reedy. Riley. Sauls. Schroer.
By your vote of 8 ayes, 0 noes, you voted do pass House Bill 1551. All right, we'll now move into public hearing. Two representatives have bills in other committees, so I'm going to move both those a little bit out of order. But House Bill 2443, Representative Griffith, please proceed when you are ready.
Thank you, Mr. Chair, members of the committee. I'm Representative Dave Griffith. I represent the 60th District, which is right here in Jefferson City. I'm here to present to you House Bill 2443. It is commonly referred to as the Condemnation Proceedings Bill. What this bill would do would assist cities to acquire and rehabilitate dilapidated and deteriorated buildings that are damaged in certain neighborhoods. While the heritage value concept was well-intentioned, there has been some unintended consequences adding cost up to additional of structures that are harming the surrounding neighborhoods. Because of the only qualification for entitled of heritage value is the passing of time. Another unintended consequence is the potential that would create a negative incentive to hold onto properties without taking care of them and to maintain the structure. There's a moral imperative to not reward with extra compensation individuals who refuse to take care of their properties and create burdens like higher crimes, lower property values, and increased need to public services like police, fire, code enforcement, and their neighborhood. Loss of heritage value would not be automatic, but it would need to be reviewed by the court and would be appealable. This bill is maintained and really for urban areas only. It does not have anything to do with farmland. I had some concerns from the Farm Bureau today and explained to them what this is all about. And if there are no, I open myself up for any questions you might have.
Questions by committee. Representative Veet.
I want to thank you for bringing this bill forward. Heritage value has a real purpose, but it's certainly when someone abandons their property or lets it become a nuisance or it's demolished because they failed to take care of it. I don't think they had a whole lot of pride in their home to start with, so you're really not taking anything away. You're letting them abandon the property and then ask for a bonus. So I agree, and thank you for your bill.
Well, we got some, and thank you, Representative. We've got some issues here in Jefferson City, but it's not just Jefferson City, and I think I've got some witnesses that are going to testify today to that same fact that this is a problem that we have throughout the entire state.
All right, other questions by committee? Seeing none, thank you, Representative.
Thank you, Mr. Chairman.
Anyone here to testify in favor of House Bill 2443, please come up, state your name, and yeah, it looks like you filled out the witness form. Just drop that off.
Thank you. I'm Carrie Turgeon, Mayor of Jefferson City, and thank you for hearing this bill. This is very important to us, and for many of you, you have seen firsthand the effect of this item right outside the Capitol doors on Capitol Avenue, just literally feet from the Capitol. We have several properties that are owned by mostly one property owner, Barbara Busher, who has accumulated several properties during her lifetime and has let them basically go. In fact, they are dangerous now, so that's where the city has intervened. And you may drive down Capitol Avenue. In fact, you probably have and seen these properties that look like they're starting to cave in on themselves because they are, and wondered, why isn't anyone doing anything about them? Well, we play by the rules. The property owner still owns them, and really the city can't intervene until they get to the stage. We follow the state laws that we have to and work with the property owner to try to remedy the situation. But in our case, as you can see, looking out at these properties, unfortunately, the property owner has allowed them to fall into such disrepair. So the city has to intervene. We don't have a choice. And as part of that, we have to go through the process to pay the property owner for the property. And unfortunately, the heritage clause adds 50% extra to the appraised value. So essentially, like Representative Griffith said, we are rewarding and incentivizing really property owners like that who unfortunately have allowed their properties to fall into disrepair. So these properties you can see for yourself. I know other cities deal with this as well. They're dilapidated. They are dangerous. They're uninhabitable. They invite crime. And so our first responders, our police officers and firefighters are putting their lives at risk when they have to go in there. And so the city has to intervene, and in the meantime, we're having to almost pay extra and a bonus really to the property owner for allowing this to happen. So we realize it needs to be very narrow and very specific of when this can be used. And the example that I gave you is really that type of a situation. Unfortunately, that has happened. And so that's why we really need that so that we can acquire these properties and allow them to be repaired or in most cases, unfortunately, demolished. So we thank you for your time. Our city attorney, Ryan Molman. Mr. Molman is here as well. If you have any technical questions on the bill, he could certainly answer that too. Thank you.
All right, committee questions. Seeing none, thank you for coming.
Thank you.
Who else in favor of the bill?
Thank you. My name is Ryan Molman. I'm city attorney for Jefferson City. And Mayor Turgeon really covered most of the bases that the city wanted to cover. But I just wanted to give a real world example of kind of what we are talking about. There's a property at 401 East Capitol, and it's 3 blocks to the east of the Capitol at the corner of Adams and Capitol. And in the last 5 days, it has been broken into 3 times for various illicit and illegal activities. It's a safe haven for criminals. And so in the last 5 days, broken into 3 times, it's my estimate that the city has spent $1,000 resecuring, putting the lives of our code enforcement and public safety officers in danger to go into those buildings to clear them first to make sure we're not, boarding someone up inside the structure. And so that is the type of activity that this bill is meant to address, and the property type that we're trying to address here. And we do not think it a wise use of taxpayer dollars when going through a condemnation process to acquire these problematic properties and get the neighborhoods back on track, that the property owners who have allowed these properties to fall into these dangerous and really burdensome conditions, it's not fair to the taxpayers to have to pay extra compensation just because the property has been held in the same family for the past 50 years. It's our position that when you have started to allow your buildings to fall apart and become safe havens for crime and other illicit activities, that you've abandoned your right to extra compensation. So the regular compensation procedures, guaranteed under the state and in federal constitution for just compensation, still apply. We're just looking for this extra bonus, which is a creature of state law, to not apply to these certain extreme conditions. And I'd be happy to answer any other questions.
All right, questions by committee? All right, seeing none, thank you. Who's next in favor of this bill?
Good afternoon, Mr. Chairman, members of the committee. My name is Richard Sheets. I'm with the Missouri Municipal League. Municipal League represents 650 cities across the state of Missouri, and we're in support of 2443. The issue of dealing with abandoned and dilapidated buildings is a statewide issue. Many of our small, medium, large cities all deal with this issue, and this would just benefit all those cities that have to address those abandoned buildings through condemnation. I'll try to answer any questions if I can.
Questions by committee? Seeing none?
Thank you.
Brief, thanks. Who's next in favor? Seeing none, anyone here to testify in opposition to House Bill 2443? Seeing none. Anyone here to testify for informational purposes only? Seeing none. That concludes the hearing on House Bill 2443. And then moving to hearing on House Bill 2703, Representative McGaugh, please proceed when you are ready.
Thank you very much, committee chair, vice chair, and esteemed members of the committee. This is my first time before your committee, and I thank you for taking this bill. So my name, for the record, is Representative Peggy McGaugh. I represent the 39th District, which is in northwest Missouri, Ray, Carroll, and Sheridan counties. I proudly served as the Carroll County Clerk for 3 decades prior to my running for state rep in a special election succeeding my son, Joe Don McGaugh. I served as the Missouri Association of Counties president in 2009. I have a wide range of friends throughout the state that are elected officials and their staffs, and we have annual meetings, and we have monthly meetings as well, when we talk about things that are working well in our counties and things that are not working well and costing the counties money. So this particular bill was filed to help the counties who have had to utilize the Judicial Finance Commission. So in this bill, it requires the Attorney General to provide representation to the circuit courts in the proceedings before the Judicial Finance Commission. Additionally, the bill provides that any legal fees incurred by the circuit court in such proceedings shall be paid from the state legal expense fund and not from any funds of the county involved in the proceedings. And the reason why they have asked for this is numerous counties have utilized the Finance Commission, but it costs them sometimes more than what it is that they went to court regarding. So I have expert witnesses behind me from the counties who've actually been before the Finance Commission. I think they can probably answer the questions more than I can, but I'd be happy to answer any questions if you have any of me.
All right, questions by the committee? Chair just has a couple. I had the honor of serving on the Judicial Finance Commission for several years, so I have a little knowledge of how that works. The legal defense fund is my question, and maybe one of these other experts can answer. An amendment in this bill, do you believe that would have the effect of amending the legal defense statute to make that an authorized use under that particular statute? Or would we have to also amend the statutes dealing with the legal defense fund to make it a allowable expense? Because we don't want to pass a bill that says use the legal defense fund, and then the legal defense fund says, sorry, that's not authorized use.
I understand what you're asking me. I don't really have the answer for that. I think probably you, as the experienced attorney and one that has been on the commission, might. We would entertain to learn as we forward this bill.
Okay, sure. And second, it does allow the presiding judge to, I guess, request the Attorney General. Would the judge be allowed to seek private counsel under this to be paid out of the legal defense fund, or would it be limited to the Attorney General? Because typically, I know you mentioned this happens a lot, but there are not a lot of these hearings that go on, quite frankly. I believe when I was appointed, there hadn't been an actual hearing in 20 years that it got to that hearing stage, that final stage. But would the judge have the option of using private counsel, which is a rather specialized field of the law, or would they be limited to using the Attorney General?
I believe the wording on page 3, subsection 11, just represents any legal services required for representation of the circuit court in a proceeding of the Judicial Financial Commission. So it doesn't make reference to outside attorneys, as I read it.
Okay. So as far as your interpretation, it would limit it to the Attorney General.
I believe that was the intent of the bill.
Okay. All right. Other questions by the committee? Representative Veet.
I want to thank you for bringing this bill because it seems kind of odd to me that the county commission would hire their lawyer and hire the lawyer to represent the opposite side of them. That certainly creates an appearance of impropriety and a strange situation where you're hiring the lawyers to go against you. And this gives at least the appearance of the Attorney General being independent and representing the circuit court as it needs represented. Thank you.
I believe you've boiled that down to what the problem is. It's a no-win situation for the counties. They feel like they have things that they could come out on top of, but they're paying for, as you say, all the legal fees.
And certainly for settlement purposes or getting something resolved, when one side's paying attorney's fees and the other isn't, it's kind of an incentive for one side not to be too accommodating. The other side has to be accommodating us because the fees just go up more than, they win the battle and lose the war. So thank you for bringing the bill.
You're welcome. Thank you.
Other questions by committee? All right. Thank you very much. Others to testify in favor of the bill, if you'd please come up, leave the form, and state your name. Please proceed.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Steve Hobbs. I'm the lobbyist and executive director for the Missouri Association of Counties, representing almost 1,500 county elected officials statewide. Came here today to testify in support of House Bill 2703 and want to thank the representative for bringing this forward. I was excited to learn that the chair had been on Judicial Finance before. Before I took this position, I was on the Judicial Finance Committee from 2015 16 until I accepted this position last fall. So I assume you got to work with Judge Mooney some?
Even though typically we don't answer questions, you betcha.
What a great guy.
A great guy. Yeah, fantastic, who always tried to arbitrate, mitigate, mediate those cases, usually was successful.
Yeah, and we're really blessed to have Judge Robert Clayton as the chair of Judicial Finance now, and he does a fabulous job as well. For members that aren't familiar with Judicial Finance, it's a committee made up of 3 judges that are circuit judges that rotate in and out, and 3 county commissioners. Usually we try and keep it separated by classifications and geographic areas, and then it's chaired by a member of, right now, the Eastern Appellate Court. And they mediate disputes between judges and county commissioners on budgetary items. It was originally set up in '95 to look at juvenile budgets and to make sure maintenance of effort were paid. That's a large part of what used to be in front of it. We've seen a discouraging trend in the last few years, however, that we're having about 1 case per year on average where a county and a judge cannot come to agreement on budget. And I've got some people behind me here that have lived through these in the last few years, where literally hundreds of thousands of dollars have been spent over disputes. And the whole idea, just as this General Assembly is based on, of compromise and negotiation to get to a point where people are in agreement, it's kind of hard to negotiate with someone when one side doesn't have any bargaining power. And essentially that's what has happened through this process. The judge, if he or she decides that they want to sue the commission over a budgetary item, picks their attorney, and the county pays for both the county's representation and the judges. And I think there's a lack of fairness in that. I'm heartened, too, that the the representative brought it to the Judiciary Committee because, quite frankly, we've struggled with what the right fix for this would be, on which, how that would work. We've talked about several different options over the years, and we figured that this group right here would be able to come up with a solution that might be palatable to both sides and bring those people to negotiate in good faith to the table again. With that, I'll end my testimony. I'm happy to answer any questions from the committee, and I've got some experts behind me.
All right. Chair would have a question. The same question I had before to the representative. Do you know if this is an authorized use under the Legal Defense Fund? It seems rather odd that we would approve something that was not an authorized payment and then say that's fair.
I don't think it probably is.
So it may require an amendment of that statute as well.
Yes, it might do that. You know,
Okay.
I don't think people thought about this, that this would be a problem at the time.
And it may not. I'm not that familiar with the Legal Defense Fund, but I've never seen it there
Yeah.
as an authorized use. All right, other questions by the committee? Wow, okay, seeing none, thank you. Oh, one other further question I had. You indicate, I think you said the court can request an appeal to the Judicial Finance. It can only be appealed by the county, I believe, is correct.
Right, yes, and I misspoke on that. Yeah, the county is the one that would request that if they can't come to an agreement.
Right.
And there are firm dates on when that can be done,
Right.
as you're well aware.
Right, okay. Any other questions? Seeing none, thank you.
Thank you.
Who else in favor? Coming up, if you'd state your name.
Thank you all for allowing me to be here today. I'm Alan White, Presiding Commissioner of Macon County, and I'm in favor of the bill 2703. And we have been to Judicial Finance twice in 2016 and 2019. It's cost us probably $50,000 in legal fees. We feel like we've kind of maybe broke even over the years. We got 2-3 year deals. We were real close to going again this year. We kind of worked it out. I think if we had the circuit judges, attorneys being paid by the state, it would give the judges more reason to sit down and bargain with us and discuss budget issues. And what we normally have our problem is in the juvenile office and attorneys that they require. We're working for just a little relief, a little more fairness in the system. So that's basically what I'm here to ask, is that you consider this bill and maybe we can work out something that would be more fair to the counties in the future, so that we're not on the hook for both attorneys. I'd be glad to answer any questions about either one of our cases that we went. And we did not go, we ended up going to just the mediation part and not the full court hearings. That could, after the mediation, we could have appealed and asked to go to the full hearing, and we never done that. We just went with the mediation and resolved some of the issues. And the last time we went, our judge was asking for an increase for the juvenile officer lawyer from $20,000 to $61,000 in 1 year jump. And when we got there, they was willing to take 35. So if we could have done that to start with, we wouldn't have probably went to the Judicial Finance. So, I mean, it didn't take but an hour down there, and they was willing to come down that much on that particular issue. So it also, we paid for a lawyer for them to do that, which if we just negotiated at home, we wouldn't have had to done that. So we appreciate your time, and thank you. Any questions?
Sure. Questions by the committee? Seeing none, thank you.
Thank
you. And did you fill out a witness form just to double check? Okay, very good. Who's next in favor?
Good evening, Chairman, Committee. My name is Mark Thompson. I am the Associate Commissioner from Adair County. I'm also the Vice President of the County Commissioners Association of the State of Missouri. We've spoken about Judicial Finance Commission for a long time. I lived through Judicial Finance Commission. Your buddy, Judge Mooney, was a wonderful person. When we went to the appeal court, we have worked with some very, very wonderful people, judges, commissioners through the Judicial Finance Commission. And, I'm thankful for that. The Adair County is thankful for that. The concern that we have, and you've heard already this afternoon, is the fairness as far as the county paying for our lawyer and their lawyer. We don't hire their lawyer. The judge hires a lawyer that represents him. So I wanted to address that. But in Adair County, the numbers I saw initially was something like $470,000 that we had in legal expenses after we went through litigation and some discussions with a fine lawyer from Boone County. We had some concessions, and finally, our expenses, legal expenses, after negotiating, was about a little over $100,000. But that's still a lot of money. A lot of these counties, Adair County is not a rich county, nor was Macon County. So our concern is the fairness of what the Judicial Finance Commission, how it's set up, and how it's funded. It's very, very simple. Very, very simple. Why did I get involved in it? The first couple years that I was a commissioner, the presiding commissioner had a daughter who wanted to work at the juvenile center. Can you guess where I'm going with this? She got a job out there, and the presiding commissioner took care of her employment, and he was also the one that approved the budget for a couple of years until I came on and some other commissioners came on. We saw what was going on, and we said, hey, we're going to do this, we're going to do it right. We did see some problems. As a matter of fact, he didn't like me coming on there. He threatened to throw me in jail because I would not accept his budget proposal and the other two commissioners. So I don't want to badmouth anybody. My mom told me a long time ago, if I can't say something nice about somebody, don't say anything at all. But I'm going to be truthful with you. My concern is we have very smart people here today. What I'd like to see happen is for the counties not to pay for the legal expenses for the judge. It's a very, very simple request. So I'd like to keep it short. Have any questions for this old farm boy?
All right, questions by the committee? Seeing none, thank you very much.
Thank you.
Who's next in favor of the bill? Seeing none, anyone to testify in opposition? Seeing none, anyone here for informational purposes only? Seeing none. That concludes the hearing on House Bill 2703. All right, jumping forward, Representative Veet, House Bill 15, nope, we're going to backtrack, Representative. I skipped over Representative Ritchie because they asked to go first. They had other bills, so thank you for waiting. House Bill 1546, Representative Ritchie, when you are ready, please proceed.
Thank you, Mr. Chair, Committee. For the record, Doug Ritchie, State Rep for 38th District, Eastern Clay County, and looking forward to answering any questions regarding House Bill 1546. This bill was filed a few years ago as well, came through Judiciary at that time. What this bill does, in essence, is it provides civil immunity for nonprofits, not-for-profits, churches, organizations similar to those that when they are contacted by another nonprofit, church, not-for-profit, looking at the possibility of hiring an individual that was previously employed or bringing somebody into a volunteer mix that had volunteered at that entity. Whenever let's say, for instance, a church receives that phone call, currently, if they know that there was a claim of sexual impropriety of some sort. In other words, there was an allegation that was made against the individual that may not have necessarily risen to the level of a mandatory reporting incident, but certainly cross the lines of appropriate and respectful interaction between adults. That typically now, under current law, most are just simply not going to feel that they have the liberty to divulge that kind of information. Most employers, quite frankly, today will virtually only stick with date of hire, date of departure, and they might answer the question, if you had the opportunity, would you hire the individual back, right? So you're talking about, this is the job they had, this is when they started, and this is when they left, and that's it. And we all know why that's the case. But in situations where there has been sexual impropriety, maybe there was some pressure that was created relationally and it was not appreciated, then the individual, knowing that there had been some allegations made, that individual leaves on their own cognizance. At that point, what is then left to be done when you find out that they went down the road to another charity, right? So what this bill does is it gives them the ability to know that they would be protected when they share what they know to be a truthful claim, free of actual malice, regarding that particular scenario. This is driven by the fact that most people understand that the way that predators operate, they go through grooming processes, and whenever they begin to find that the context they're working within begins to kind of hem them in, they will then leave before something is that rises to the level of either one, if it's related to a juvenile, where it hasn't risen yet to a mandatory reporting situation, or that there's not criminal conduct, they'll leave. And then the next charity down the road, they'll do a background check, and as we all know, nothing's going to pop on a background check because there's not been any, guilt established by a court of law regarding these types of activities. So the language in front of you basically is reflective of a law that was passed in Texas a few years ago that was addressing the same matter. It is working to protect direct, truthful disclosures from one charity to another by an individual who is either an employee or operating as a representative of that charity, speaking to another charity, or someone's representing that other charity. This is also something that that is tied to what the Supreme Court has identified in terms of their definition of actual malice. You guys know I'm not an attorney, but I'm going to give you the reference, and hopefully this is helpful. But when it comes to actual malice, the Supreme Court, in their decision, New York Times v. Sullivan in 1964, helps to establish the anchoring definition to what you have here in the bill. And the one additional comment that I'll make, and then I'll see if there are any questions. In Oklahoma, back in 1989, in the case Quinn v. Church of Christ of Collinsville, the state actually ruled against the church in an incident similar to this, and that particular case has been referenced 60 times, related to matters of divulging information that that the church believed to be credible and necessary for another church to be aware of regarding that individual. And what that does, as you all know, especially as it's referenced some 60 times, there is a cooling effect. And I know that I'll just speak personally. You guys know that I've been a pastor for over 2 decades, and I can tell you that I know of too many instances where there was an individual that was operating within the context of a church that is supposed to be a trusted entity, interacting with those who oftentimes find themselves very vulnerable and they're in need of care and assistance. The predatorial types know that most churches and nonprofits are hungry for volunteers, and they also have easy access to people who are vulnerable. And what happens is these individuals will come in and they will exploit those relationships, and sometimes they will then ultimately cross a line, and lives are devastated as a result. And then you determine, as a result of all that, they start going back, and there had been a history of particular activities and the way that they conducted themselves in relationships that never crossed the line of criminal activity, never required mandatory reporting, but you start to see the predatory behavior, but it's in the rearview mirror. And what this bill is trying to do is to give those earlier instances the opportunity to be exposed, again, when a church or nonprofit knows something to be truthful. I mean, they're speaking truthfully regarding an allegation that was credible to another charity. And, so that's the backdrop. That's what the bill is trying to accomplish. I do believe that this would be tremendously helpful in closing the door, at least to some predatory activity in the context of nonprofits and churches.
All right. The Chair will have a couple questions and passed around the committee. This is similar or the same bill maybe that passed out of the House last year? Last couple years?
It came to the Judiciary and we ran out of time. I filed it the first time 2 years ago, and that was when everything shut down with COVID.
Right. Okay. Yeah, because we've, I think, heard this bill before.
Yes, you have.
Right. Yes. Earlier this week, and I've already talked to you, and you were very receptive, the ranking minority member, the vice chair. We try to meet every week if possible. We looked over the bill again, and if what we try to do in this committee is to make bills stronger legally. And you indicated you'd be very receptive to sitting down and discussing possible amendments.
Yes.
All right. Yes. Who else? Representative Sauls.
Thank you, to inquire.
Go right ahead.
Thank you. Just got a couple of quick questions. So is this specifically designed for slander and libel? Is there anything else that you're contemplating this to block or to prevent? Go ahead.
No, I mean, it's basically related to those communications, right? So, I mean, when you're looking at line 6, to the extent the communication concerns an allegation. So this is when, let's say, for instance, I were to get a phone call and they're like, hey, is John Doe, I noticed that he worked at your church during this period of time. If I knew something to be truthful in terms of what's been communicated to us, there was a credible allegation, for me to then truthfully divulge that to this other church, that's what would be protected. So it would be, what do you call it? It's qualified privilege, I guess, right? I mean, there would be a matter of qualified privilege in that divulging of the details.
I understand that. That's the only thing I can think of is slander and libel in this situation. So that it's the communication that you're talking about. I guess the other part I'm struggling with is that what you're talking about is truthful, right? Which slander and truth is a defense to those types of matters. So in a situation such as that, I'm trying to figure out how this is even, like if this is even happening, and if it is happening. And you mentioned one case in Texas, or what did you say?
Oklahoma.
Oklahoma, sorry. Okay. So, and of course, I can look at that. So I'm just kind of curious.
Yeah.
What
I think what you're really dealing with, I mean, if I'm understanding the direction of your question, I think really what you're dealing with in, quite frankly, even in just general employment situations, people are very uncomfortable with speaking about a prior employee or volunteer beyond dates of employment and the job tasks that they were assigned. So if you have a situation where somebody was acting inappropriately to say something, there's definitely a cooling effect that has occurred over many years of employment law and litigation and things of that nature. And what this would be doing is saying to these nonprofits, listen, when you know something to have been reported, it came to your knowledge, but it didn't rise to the level of criminal activity or something that required the mandatory reporting, you can divulge that, because quite frankly, that is necessary to make sure that that next nonprofit and those they serve are protected for someone who may be operating in a predatory fashion. And one thing on the mandatory reporting too, I think that is kind of important. This does also, if something did require legally mandatory reporting, you can't divulge that unless you actually did report it, right? So that's another, there's an incentive there to make sure that if you were aware, if as a senior pastor I was aware of some kind of an abuse or neglect of a minor that came to my attention and I never reported that, and then a year later I get a phone call, I'm like, well, we had this credible accusation. If I never reported that, I would be in violation of this because I should have, based on current law.
And what would you consider actual malice? Because, like in the context of in these circumstances, if someone says, I'm thinking about because you keep talking about truthful, right? So I mean, at the end of the day, if it's truthful, I see that as a defense to any. I mean, if they're going to say, this person, this pastor said something that was and damaged my reputation, then ultimately the truth is a defense to that. So. I guess where in the lines of, you don't necessarily know it to be true, but it, you heard through the grapevine or something like that. Where does malice fall within that?
Well, you are a veteran when it comes to the law in a way that I am not. I think that the definition that was established by the Supreme Court would be the thing that drives the train on that question. So in defining actual malice, I think the Supreme Court provides that. But certainly, if I knew something to be false, if I knew something to not be accurate, truthful, and I try to destroy another person's character willfully, and I share something that I know to be not true, I think that would cross the line of actual malice. But yeah, I wish that I had more to draw from.
Sure.
It's New York Times v. Sullivan, 1964. So
yeah.
I don't know.
I've read that one.
I'm sure you probably have.
Yeah.
So yeah.
All right. Thank you.
Other questions by committee? Representative Black, please proceed.
Thank you, gentlemen. Thank you for bringing this forward. It's clearly a problem. We don't want predators going from one place to another because the last place they worked is afraid to let people know what happened. But it is a fine line, as the gentleman has suggested. This happens in the regular employment context too, as probably a lot of us are aware, where just a regular employee going from one job to another, the previous employers are afraid to say they did a crummy job. And this is a much more concerning situation. So with regard to the New York Times standard, I'm going to ask you a few questions with regard to what you really think should be the appropriate standard in these cases. And the standard you're talking about applies to public figures. So the basic concept is if somebody's a public figure, probably like all of us, if somebody says something bad against us, they have to have known it was wrong or with reckless disregard made the statement anyway. So you're giving, so to cause somebody to be liable for, or not immune in this case, not immune, they would have had to acted at a pretty high level of disregard for the character of another person, and as opposed to mere negligence would be the probably low end of the scale, that they really shouldn't have done that. And I'm asking you if that's the standard that you think should be applicable in this kind of case, or should the immunity follow and be granted even if the high level of disregard was not there. And I said that very awkwardly. In what circumstances really do you think, in this circumstance, based on your many years of experience, that a person should not be able to have immunity from saying something about a bad situation that occurred in their church?
I think that what I'm trying to accomplish here and what is reflective of the Texas law was the actual malice being the threshold. So not mere negligence where you were trying to do the right thing, you believed it to be true, you were acting on what you believed to be a credible accusation or allegation. That would not put you in a position where, if found later to be false, that you would lose your immunity. But rather, if you truly could be shown to have had ample opportunity to have known this thing was not true, and you were working to assassinate someone's character, then you would not be protected. That's the threshold there. It's just one of those areas, and this is, I will acknowledge, it is a tough area. It's similar to what we dealt with a couple of years ago, I think, with Representative Miller's bill on Don't Pass the Trash in terms of schools, when they have, teachers, coaches, whatever, that are engaged in certain things, and sometimes it's just really hard. What do you do? They just bounce from one school to another school, and we went ahead and gave districts not only the coverage, but also the mandate. You have to share if you know something to have been credible in terms of that particular teacher's activities. It's kind of similar in that respect. There are times where you have individuals that you have a female that, quite frankly, is feeling very, very uncomfortable around a co-volunteer or a co-worker, and that person is not being respectful, and then whenever the accusation comes up, they just quit or they walk away as a volunteer. Now, what do you do? It's like, and then you get a phone call 6 months later, hey, did such and such, yes, he volunteered during this period. It's extremely difficult for charitable organizations, churches included, to be able to weed out predatory individuals without being able to have a better understanding of the history of these individuals. I've got a friend that at one point they brought in somebody to work with their youth from out of state. They did a background check. There was nothing. That's all you can do. And then this individual ends up engaging in some stuff that was more than criminal, and thankfully law enforcement and authorities got involved and what have you. But then they start going back into the history of this person and realize that this individual had behavioral indicators that never came out, because how do you communicate that? And that's really what this is trying to do. It's trying to remove any kind of barrier that would disincentivize an honest communication of what that charitable organization believes to be true regarding an appropriate form of communication about a concerning circumstance, and saying, listen, yes, he, she were here during these dates, did this thing as far as the task that was assigned, and you need to know there was what we believe to be a truthful, credible allegation of sexual or, some other kind, as you'll see in the definitions, that operated in a way that was, reflecting conduct that would prove their unfitness for religious ministry. And then it's up to them, right? But you've done what you can in that context. So I'm taking a long time here in answering your question. The only threshold legally that I can point to, and you guys are the attorneys, and I trust. You guys all, I believe, honestly, would have your head in the right place in terms of trying to make sure that what we're attempting to accomplish can be accomplished with whatever definitional anchoring point needs to be established if actual malice is not the one that you guys think is appropriate. It has proven to be appropriate, in my understanding, in terms of attorneys that I've talked to on this in the past. So,
Thank you, gentlemen. And I understand from your communication that apparently senior pastors are mandatory reporters. Is that right?
yeah, per state statute, ministers are mandatory reporters.
All ministers?
There's a reference.
Licensed ministers? I'm sorry, I'm not familiar with that provision of law, and I didn't look it up.
Yeah, I mean, it would have to. I believe it's in.
I think you even
566?
referenced it 210, and I was just too lazy to look it up.
Well, there are a couple of references. I think the in 210, 109 through 183, but there's also a reference. Yeah, it would be in that context, 210. Yeah,
And
it references ministers.
And most ministers, you believe, are aware of that obligation and as part of their professional duties.
There is a reference in that chapter that helps to further define the areas when a minister is a mandatory reporter and other areas where they may not be, because there's a lot of history on what a member of clergy can be forced to divulge before the court.
Yeah.
But when it comes to the victimization of children, I think most every minister knows that you're a mandatory reporter.
Thank you, gentlemen.
Representative Veet, questions?
I'll be short. You know, I have always a little bit of concern when you give people absolute immunity, and malice here is a different level than what we're talking about with public figures. And when you say actual malice, that means intent. And I'm more concerned about the, you know, and the defense is, if it's true, there is no problem. And you, how you say something, you know, you say, I heard they did A, B, and C, that's what you heard. I'm more concerned, would you have a problem if we said actual malice or reckless indifference to the truth and veracity of the statement?
Yeah, I think I don't know that I would have any problem with that.
Okay. I have no further questions.
Thanks.
Any other questions about the committee? All right, seeing none, thank you very much.
Thank you.
Anyone here to testify in favor of the bill? Seeing none, anyone? Yes, come on up. Speak now, or forever hold your peace.
Chair, members of the committee, Jessica Petrie here on behalf of Missouri Kids First. Missouri Kids First is the network of 15 child advocacy centers around the state. Sorry, were you not able to hear me? Is this better?
I think you were heard online, but maybe not in the room, was not picking up on the mic.
Oh, I apologize for that. So Missouri Kids First is the network of the state's 15 child advocacy centers that serve children who have suffered child sexual or physical abuse, and also try to support adults in the community in protecting children from abuse. And we think this is an important step toward making sure that youth-serving organizations, including nonprofits and churches, have the ability to disclose troubling allegations to future employers. We think one of the reasons why nonprofits don't share that information is because they're afraid of being sued. And because youth-serving organizations have such unique access, where adults are able to get close to children, sometimes in unsupervised environments, I just think this is a really important step toward making sure that if people have patterns of troubling behavior, future employers find out, hopefully before it's too late and something more problematic happens down the road. So we appreciate Representative Ritchie working on this issue.
All right, questions by committee? Seeing none, thank you very much. Anyone else in favor? Don't want to miss anybody. Anyone in opposition to the bill? Seeing none. Anyone here for informational purposes only? Seeing none, that concludes the public hearing on House Bill 1546. Thank you, Representative. Now to House Bill 1549. Representative Veet, please proceed when you are ready.
Mr. Chairman, members of the committee, thank you for your time. This bill is known as the Uniform Interstate Deposition and Discovery Act. This bill was heard last year. It made it all the way through, I think, and it was one of those that died on the last day. But for those of you who are not familiar with the bill is, the situation we have now is when corporations or someone sends a subpoena from out of state, it creates a problem. One, they don't know, without looking through our rules real close, it's hard to find. But if they want to serve a subpoena right, they have to file a lawsuit here in our state and get service, and then actually proceed with getting the deposition set up, which creates additional work. The other problem is lawyers from other states and people who are not familiar because we don't have a uniform method are just mailing subpoenas to people and they're getting a subpoena served upon them. They causes them panic. They've got to get a lawyer. That lawyer then decides what he wants to do, whether just ignore it because it's not properly served or try to resolve it and file some type of stay, which is all unnecessary litigation. Not that I'm opposed to litigation, but I am opposed to unnecessary litigation. And this bill simply provides that they can send a notice to the clerk. She then can issue the subpoena. The subpoena is issued. The person receiving it then knows right on the subpoena if they oppose it that it will go for instance, if you want to oppose it on what the discovery requests are, all those issues can simply be brought in the circuit that you live in, and there also makes it clear the rules of discovering that are you're applying Missouri rules. And it just brings our state in compliance with what many other states are doing. Anytime you have some bill that isn't consistent and made consistent, you're just asking for confusion and additional litigation. Any questions?
Questions by committee? Representative Black.
Thank you. You're right, gentlemen. This is a pain when you get served with one of these defective subpoenas and you don't know what to do, and do you try to quash it or do you ignore it? Or I noticed that your bill doesn't go as far, and I'm wondering if under the Uniform Act there's provision that you can just ignore it.
Well, I've talked to some lawyers, and they said, yeah, you can ignore it, and technically they haven't complied with it, but who wants to take that risk?
That's what I'm getting at. So I'm wondering if there might not be and if it's Uniform Act, I understand the problem, but there might be a provision that if it's defectively served, then some language to protect the business or the person that received the defective subpoena. Have you seen anything like that?
No, but I will acknowledge even some of my bills can use a little improvement. So if you would like to make an
Tell me it ain't so.
So, I'm not opposed to that. It's the Uniform Act. I don't want to go deviate too far from it, so it's uniform. But, that's a risk we're having right now, and you're in the business. A corporation, someone serves a subpoena on you to divulge all your employees' records or something, then, and you go, what did I do? And if it comes from the circuit clerk, it has right on there what you need to do. There's a hearing already set up. And so I think it just clarifies it. We're doing business with a lot of other corporations around the country, and they have served subpoenas on it. It's just mainly to clarify the records so everybody knows, because I actually had to go look up and had different lawyers tell me how to get an out-of-state subpoena served. But I do know that it is possible. It's just a matter you're going to have to hire a lawyer here, which is good for the legal profession, but not necessarily good for business. And then you have to get a whole lawsuit and a whole hearing set up.
Thanks, gentlemen.
Just following up on his question, are you aware of any provisions in the uniform law or otherwise other states that would allow for payment of attorney fees if you had to hire an attorney and it was an improper subpoena or a request and you had to defend it when the law did not allow it?
I am not aware of that. We generally don't. Generally speaking, in our judicial system, attorney's fees are usually something that are not freely given just because someone else has made a mistake. But I'm not opposed to that. I want the people, when they're going to serve subpoena and dump it on somebody and request something from somebody, because when you're served subpoena, whether it's just they want some employees' records or something, it takes time and effort to do it. So, or they may give a subpoena that's way too broad. And so that is a debate with But I'm not opposed to, at least that a court could, if they find the subpoena is, overly broad, et cetera, and you have to go into court, that they can award attorney's fees for it. Because that's the next thing, that you get a subpoena and it's got all kinds of stuff in that they know that you're not entitled to, and they ask for employees' records and A, B, and C. If they are abusing the subpoena process, I'm not opposed to having a provision in there that a court could, because if you're going to object to it, you have a court in your county, you're not going back to their home state. Your county could impose sanctions.
Okay, something to think about. Other questions about the committee? Seeing none. Anyone in favor of the bill? Anyone here to testify in favor of the bill?
Brian Bernskater here on behalf of the Missouri Association of Criminal Defense Lawyers and the Missouri Organization of Defense Lawyers. Representative Rudy V. said it all. We support it. Thank you.
Questions by committee? Same question to you. Are there provisions anywhere else that talk about sanctions, anything of that nature?
I'm sorry. I was trying to furiously look, and I'm not aware. So I can get you that answer. I'll collaborate with Representative V.
Okay, very good. Any other questions? Seeing none. Anyone else in favor? Anyone here in opposition? Seeing none. Anyone here for informational purposes? Seeing none. That concludes the hearing on House Bill 1549. Moving next in, the last bill, House Bill 2774, Representative Riley. Please proceed when you are ready.
Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Alex Riley, and I represent the 134th District, which covers parts of Springfield and Greene County. Thank you for allowing me to present House Bill 2774 to you tonight, dealing with a few things related to guardians ad litem. And just as a quick refresher, and for anyone who may be listening this evening, guardians ad litem are folks that are tasked with representing the best interests of our state's kids when kids are involved one way or another in various types of litigation. For example, child custody, divorce, adoptions, and then probably most tragically in cases involving abuse and neglect. Guardians ad litem, or GALs, as we frequently refer them as, have a really important role in our state and our society, and their job is to investigate the case and ultimately provide recommendations about solutions to the court on what the best interests of the child are going to be in particular matters. And they typically work the case until it's over, unless for some reason they need to withdraw. And by and large, our GALs do really incredible work under really challenging circumstances. But there are challenges, and our current GAL system isn't fully taking care of the needs of our state's kids. And some of those challenges are what House Bill 2774 seeks to remedy. So just to name a handful of challenges that come up, and I know a lot of the members of the committee have worked in this world in some form or fashion in your practice, so this is not going to be new to you. But one of the problems is GALs don't always have the opportunity or ability to meet with the kids that they're tasked with representing, which can pose some challenges to their ability to properly and adequately represent the children. They don't always have the opportunity or ability to fully investigate the cases, and that provides challenges in their ability to recommend what's ultimately going to be in the best interests of the kids. There's oftentimes, unfortunately, a lack of communication between the GALs and the kids that they're tasked with representing. And a lot of these challenges really stem from a lack of financial resources in our GAL system. There's really a patchwork of how our GALs are funded. So you have some circuit courts around the state who have local rules requiring GALs to be paid certain amounts per hour for their services. You have really just a whole host of these that really has a wide range around the state. So this patchwork does result in some problems because you don't have these GALs really being adequately compensated for the services that they provide, and in turn, those services can sometimes be not quite as robust as we would like to see them be. So what House Bill 2774 does is it works to resolve some of these challenges by creating a new guardian ad litem pilot program, which provides additional funding and additional standards for our GALs to appear for and represent children in cases relating to child abuse and neglect. So that's the world that we're dealing with in this particular bill. This is a bill that was based off of something that Wyoming did a little while back. They were experiencing similar challenges in their system, and this was an approach that they identified, and it's yielded some good results for the kids in that state. So that's what we're looking at mimicking here in this state with this legislation. So a few of the key components of the bill: it establishes an Office of Guardian Ad Litem and creates a fund to pay for GAL services that elect to participate in the pilot program. So there wouldn't be any counties that are required to participate in this pilot program. It would be an opt-in for those counties that wish to participate. Under the program, fees paid to the GALs could vary depending on the type and difficulty of the case, the location, the work required, as well as attorney experience level. The bill further specifies that the program shall pay from the Guardian Ad Litem Fund, which is established in the bill, 100% of the fees for legal representation of children by GALs in the program cases. Participating counties would then reimburse the program at least 20% of the GAL fees, as well as 25% of the administrative costs. So they would have some skin in the game too. So you're going to have the state putting forth a large portion, but the counties would also have a stake as well. The bill further charges the office that is established with determining standards of representation and caseload limits to make sure that every kid that's needing GAL services is adequately represented. The bill specifically requires the office to adopt standards of representation to ensure that guardians ad litem have sufficient time to get to know the kids they're appointed to serve and to properly investigate the cases so they can make the best recommendations and really make sure that they're serving the best interests of the children as they're tasked with doing. Overall, then, this bill is designed to help address some of the compensation issues that in turn result in, unfortunately at times, poor representation being provided to our state's kids, as well as to ensure and to improve standards to make sure that each child receiving GAL services is receiving the representation necessary to look out for their best interests. And with that, I'll close and take any questions.
All right, just a couple questions, and I think this helps maybe clarify some earlier questions in the evening. Just to kind of very briefly run through the financing issues in courts, because I see your bill addressing a very practical, ongoing problem that also kind of dealt in a similar issue that came up tonight. By law, courts, and this is separation of powers, courts have no ability to appropriate funds. Is that true?
Correct.
So judges can't wave a wand and come up with money to pay an attorney, as perhaps was suggested earlier, or to pay a guardian ad litem.
Right.
And Missouri law specifically says, and the state can specifically say, we will pay for XYZ. Would you agree with that?
I would.
But if the state doesn't say we'll pay for XYZ, there's another statute that says the counties, who have long been partners in the court system dating back to the pioneer days, state pays basically the personnel and the counties, the buildings and everything else. That's been a long established practice, again, way back when. But there is a separate law that says the counties are responsible for the expenses of the court system and they're not paid by the state. Would you agree with that?
Yep, I would.
And therein lies the problem because a lot of the counties disagree that that is a function of the county, that they should be in the business of paying for guardian ad litems, or that's an unfunded mandate on the counties, and perhaps it is. But there's always a struggle in how to pay for, particularly in the small counties that may have very difficult financial issues. I'm not saying they don't, they actually do. So there's an ongoing issue of how best to pay these very necessary fees for people that represent the best interests of children. And do you see that as an issue as well?
I do.
All right, so your bill would be intended to, at least in a pilot program, look at, there are other ways of getting that fee paid for in the short and perhaps the long term.
Agreed. Correct.
All right, other questions by the committee? Representative Eat, go right ahead.
I want to thank you for bringing this bill. I'm not certain it's going to solve all the problems because there's no appropriations. I don't think it solves the problems, but I recognize that guardian ad litem is getting to be a much more specialized area, and it has its own quirks about how you do it right. And I see too many cases where the court just appoints who's ever willing to take them, and if they can find someone, and most people don't want to take them because the pay is about one half of what they would normally make. And so, it's something we need to address because these children are entitled to an attorney, and they need to be addressed. And I'll also make clear this has nothing to do with divorces and guardian ad litems of that nature, does it?
Correct.
But I also agree with the judge. What if we pass this? And I don't know why a county wouldn't join it at 20%. But if we don't appropriate money for it, we're not going to accomplish anything, right?
Yeah, that's right. This only will be helpful if there's an appropriation that we would put in there as well.
And if this is set up, the fees would be set by this commission, right?
You are correct.
The local courts would not be the ones setting the fees.
That is correct.
Just following up on that, but if the fees are paid out of the fund that the state finances, and then the commission sets the fees, so there'd be no ultimate burden on the county at that point.
Right.
Well, the county, you said, would pay 20%,
20% burden, pardon me. He's correct. All right. Other questions, Representative Eat? Yes.
Oh, thank you.
Yeah, go right ahead.
Great bill, Alex. I appreciate you bringing it. And
Thank you, Representative. I appreciate that.
Thank you.
That was quick. Other questions or comments by the committee? Seeing none, thank you. Anyone here to testify in favor of the bill? Come on up. Go right ahead.
Mr. Chairman, members of the committee, my name is Scott Penman. I'm here this evening representing Foster Adopt Connect. We're very supportive of the representative's effort. We think that having those additional standards and a caseload standard, specifically in training for GALs, is probably one of the main indicators towards helping that system to work as it's intended, to be the proper advocate for our kids in the state. Very appreciative of the overall effort. We'd be happy to work with Representative Riley, Mitchell Riley, and try and come up with a better funding, maybe even looking at some funding options for this.
All right, questions for this witness. Representative Eat, go right ahead.
Well, you addressed the one issue that I was on my mind. Is there some way we can, not that I don't believe that we'd automatically fund that out of general revenue, but it could be a challenge sometime. Is there any other way, have y'all discussed any other ways to make a funding mechanism? Because I like the concept. I like having standards, and I like having somebody training them, and I like, but I know that going to the counties and suddenly saying you're going to pay more money, it may not be the answer. So, are there any other ideas on mechanisms of funding other than general revenue?
I mean, we haven't really discussed those. We'd be happy to look into them. I mean, court fees apparently are not a very popular option at this point. But I think there may be some potential partnerships with local governments and, potentially even some of the agencies that are existing in the counties that are working with these kids and or the JO's office. I mean, there's a lot of folks that are involved, right, with some of the same kids. There might be a way to put together a partnership. But I don't have a dedicated funding suggestion this evening, but I would be happy to try and work on that.
Thank you.
Certainly one of the biggest issues is the same issue we have now, is the ongoing ability of whatever that funding source is. Of course, government has little more ongoing stability than many other private sources. So anything that we came up with would have to have the ability to make a long-term commitment, or otherwise it's short-term.
Absolutely. And I have not spoke to Representative Riley about this specifically, but trying to look at what that scope of that cost might be, it may not be an undue burden for the state to consider starting to appropriate a line item to try and work this direction. I mean, I've been involved in projects over my career where we kind of do that. We kind of front seat it, and we get the state to kind of put those initial GR dollars in. And then as the programs develop at a local level, you get that opportunity to develop those relationships and then potentially come up with that. You know, localities are now seeing that value and understanding that role, and you can kind of shift those numbers back.
And you appear to be experienced enough to remember that the state did go, I think, around 1998 to a system where the state took on the responsibility of funding for a certain amount of juvenile officers, and set a responsibility of the county, kind of locked in the responsibility of the county at that year. But they took over largely the funding of all state juvenile officers.
Yes, sir, they did, and it was a state. You know, the state made a decision to prioritize those expenditures. Because it kind of is interesting. Like starting the day we have conversations about court fees, which obviously aren't a great place to be looking, and there's specific Supreme Court rulings around that topic now. But the state has definitely taken those taken places and opportunities in our system where we say, well, we need to do this, and we've done that.
Right. All right. Other questions about the committee? Seeing none, thank you.
Thank you, sir. Our submitted form online.
Good. Very good. And he did. All right. Also in favor, come on up.
I need to put my forms in the right spot. Jessica Petrie here on behalf of Kids Win Missouri. It's a coalition of organizations and individuals devoted to promoting child well-being. GALs are a critical part of our child welfare system, and we see this as a really important effort, especially the piece around caseloads, to strengthening that. And so thank you all for the conversation.
All right. Any specific questions of this witness? Seeing none, thank you. Others in favor of this legislation? Anyone opposed? Seeing none. Anyone for informational purposes only? Seeing none. Oh, seeing one. He's hiding behind the pole. Go right ahead.
Thank you, Mr. Chairman. Members of the committee, Eric Jennings, General Counsel for the Missouri Bar. Timing is everything, and I will say that our executive committee has not completed its review of the bill, and therefore we don't have any position on it. But they did direct me to testify for informational purposes, just to make the members of the committee aware that in 2019, our then President, Ray Williams, had formed a special committee on guardians ad litem to take a broad-based look at that. We had several bills filed in the legislature. One of the key features of all of them was missing context on what guardians ad litem were, what they did, how they operated. Tonight has at least been one of the examples of the diversity and how they're funded throughout the state. And in actuality, the term system usually is a misnomer for what we actually have statewide in Missouri. But we just wanted to make sure that you were aware of that report, and I'll distribute that electronically to the extent that there's any information in it that may be relevant or useful. We just wanted to make sure that you had that, and knew that I was available to answer any questions in relation to that as well. And as soon as we've received input from our committees and members about this, we may have some more specific information for the committee.
All right, just a question or two by the chair to follow up on one of your statements or comments. It'll be softball, I'll guarantee you. Do you agree Representative Riley's bill would limit the context of this pilot program to guardians in juvenile proceedings?
It is a much narrower scope than the types of bills that have been introduced in the past that were across the board guardians ad litem, no matter what the circumstances they were involved in.
Because in fact, the role of a guardian is different in different types of proceedings. You may have a guardian in a probate case where you may work with older individuals in a different context. You may have a guardian that may represent, or a next friend that may represent a person in a civil case. You may have a guardian attorney in a domestic case on custody issues, and in a case that I kind of describe as a state-sponsored case, a case where the state of Missouri or the juvenile officer is involved, would be the juvenile case where there's allegations of abuse or neglect. So there are different types of roles of guardian ad litems in different types of proceedings in the state of Missouri. Would you concur?
Yes, and that was one of the features of the report, that the common understanding here with some of the past legislation was looking in terms of child abuse and neglect situations or something similar, and that the universe of GALs was much, much larger than that, and it wasn't a one-size-fits-all. Standards that would apply for child abuse and neglect situations weren't necessarily applicable in the cases that you outlined, where a GAL would also be present, but in a completely different capacity.
All right, other questions of this witness? Representative Eade? Okay. Nope. He passes. Thank you very much for coming. Anyone else for informational purposes that may be hiding behind that pole? All right, seeing none, that concludes the hearing on House Bill 2774. Thank you, Representative Riley, and member of our committee. That concludes the hearing for tonight. We are adjourned.